Hey everyone, welcome into an all new episode of Litigation and Capital with Steven Mirsky. I'm your host, Mike Leon. Steven is the founder of Mirsky Corporate Advisors, and in each episode, he breaks down high stakes legal issues affecting companies like yours, those earning anywhere between $10 to $100 million a year, so you can turn complexity into leverage and protect what you've built. And in today's episode, we're talking about the governing law clause. What is that? I have no idea. That's why Steven's here. Stephen, it's good to see you. What is the governing law clause? What does it actually do, and what does it actually decide?
Sure. Well, Mike, thanks for having me. Happy to be here. The governing law clause, it's a common feature in most contracts, and most people just forget about it, right? A governing law clause says, hey, this contract is governed by and construed in accordance with state X or country X or place Y. Uh, why is that important? Well, we live in a world where we have international business, and so people need to have some predictability in the contracts. The question can be, what law applies and why do we want it? So if we're negotiating a transaction, maybe we're going to want to negotiate a neutral forum so that we don't have favoritism from state A or state B. Maybe if we're in a foreign country, I've had experience with this where client was in the United States, the suppliers in Germany, they want things in Germany. Well, no, we're not going to apply German law to this, and we're not traveling to Germany to litigate any of these disputes. Let's pick a neutral place. That's a pain in the butt for both of us to get to. So those are sort of the things that go into deciding, where is a governing law going to occur. But you can have real substantive outcomes depending on the law of the jurisdiction that you're applying. Let's say state A has a more liberal state. Here's a case in point. I'll do this. This came up just a couple weeks ago. California, applying California law to a contract would give the other side a liberal way to serve somebody. When you're served with a complaint, that means you're on notice that you have to go to court, right? And in Utah law, it's very strict. So they have to strictly comply with the statute as written, whereas California affords a little bit more loosey-goosiness. So if the law is determined by Utah law or California law, these differences in each of the state's policies can come out in the litigation.
So, Stephen, that's interesting and that's a good way to frame it. So, let me ask you then. Let's say parties in the performance are happening in one state, the contract names another state. How do the courts determine whether to honor that choice?
It, of course, depends on the states. One common state in particular is New York, right? Let's say we have a party in Delaware, a party in California. They're going to stipulate to New York as a forum. If the litigation doesn't impact any of the fundamental rights within the states where the people are performed, a court more likely than not is going to address the governing law provision of the chosen state. In particular, and especially New York, New York has a statute. I can't remember it off the top of my head, but it permits the parties for certain dollar amounts to select New York as a neutral forum for both parties. So some states have adopted that policy because they want to bring in business. Think about it like that, where if we allow parties to, who are unrelated to New York, let's say, to litigate in New York, that helps all the lawyers working in New York get more business, right? So there's certain public policy aspects to this that go for it. But generally speaking, if a litigation is a litigation is commenced in, I'm just going to use California, a court will generally apply the law of the chosen state between the parties unless that's procured by fraud or violates some fundamental principle of the forum state.
So, let me ask you then, how does the governing law of an agreement affect which statutes will then apply under the chosen law?
Well, governing law and chosen law, same thing. Let's just clarify that. But the
Good to know.
the governing law, like if we say it's it's governed by California law, well, that means I get the entire body of California law. That includes all the statutes, all the case law, etc. You can't cherry pick what I don't like and what I do like. And so depending on the issue, that could cut for you or cut against you. And again, that's why when you're developing a contract or you're making a contract, you need to negotiate something that's in your favor. Now, if you're the party with leverage, well, we're going to apply the law that's most favorable to my interests, right? Which means, hey, if I'm, again, using California as an example, if I am located in Los Angeles, I'm going to want to apply the law of California because the judges around here, the lawyers around here, are all going to understand California law. And if there's an issue, we're more likely than not will prevail. And so this seemingly innocuous clause becomes a real linchpin in any litigation because it can kind of shape the procedural and the substantive issues in your favor before any fight has commenced.
It's funny that you mentioned innocuous clauses. Let me ask you about venue clauses and governing law. How do these differ? Do they matter that they're together?
It's a great question. And these are some of my favorite topics to talk about. And they're really, really nerdy. So one of the things so a governing law says, hey, the law of state X is going to apply. The venue clause states, hey, this is where we're going to duke it out if something goes wrong. And so there's a battle and there's a tension between those two items, because I can say, again, in a case that was just happened the other day, Utah law applied to the agreement. The other side filed in California, and so they sought to apply California law to the agreement. I argued that Utah law had to apply to the agreement, and I had to convince the court to apply Utah law in the determination of the issue. And so you have to think about where you're going to file these things. Do you necessarily want a foreign court to apply the law of a different jurisdiction? Maybe not. They could come out differently. So that's some of the tension that goes in there. But the governing law provision, the choice of forum, again, is also going to be freely upheld unless it's been procured by fraud or overreach. And so, again, these are very important clauses to negotiate when you're contracting or entering into a contract, because if you miss it or you just don't even look at it, you could be setting up your client or your business for failure before litigation even commences.
Entering into a contract has probably such strict wording and phrases and variations in between these governing law clauses. You wanted to get into the weeds of this. How do the variations in the wording between these clauses change potentially the legal outcome?
Sure. I've got a case right now that's going to be heard on Monday that deals with this issue exactly. Before I answer your question, let me start through how most people look at these clauses in a contract, and then I'll get into the impact. So usually when you're negotiating as an in-house lawyer, most transactional attorneys aren't going to be looking at, these governing law and venue provisions with a close eye, because their job is to keep people out of litigation, and more likely than not, we're going to settle. And so it's a kind of a throwaway, and you're not really going to sink the ship for this issue. If you're a business owner, you're certainly not looking at these terms because you're focused on the commercial terms and, hey, this is the greatest deal ever. That's why we're entering into it. But the phrasing of a governing law clause can have a material impact on the case. For instance, a very common way of phrasing this is, this state or this contract will be governed by or construed in accordance with the laws of the state of X, without regard to its internal conflicts of laws. So that's a really important statement. Why? The conflicts of law is an entire body of law that deals with, hey, if state A says A and state B says B, and there's a tension between these two outcomes, what does a court apply? And if you're disregarding that, how a court analyzes that, you have a chance of having another state's law apply even though the contract says that it's a chosen law. So, for instance, the analysis can change based on the rules regarding what most states usually do is called Restatement Section 187. Restatement Section 187 sets forth a test that helps determine which law will apply in the event of a conflict. Well, California, for instance, has adopted Restatement 187 and applies that test straightforwardly. Connecticut, for example, adds additional layers to it. And so if you disregard the different conflicts of laws and you apply both states' conflicts of law, you can have a determination that, in the case of, let's say, this Connecticut California example, that Connecticut law will not apply, even though the contract says Connecticut law should apply. But because they said without regard to the conflicts of laws principle, if you do the conflict of law analysis, California law will apply. So it's a kind of a circular loop. It's very heady. And that's why, it's a very interesting area of the law for me.
Stephen, let me ask you, how does California apply a choice of law analysis?
So California law has determined that the Restatement 187 is the way that it's going to conduct an analysis to determine which law will apply. And for those of you that don't know what that is, I'll be happy to get into that with you in just a moment. So the first step in this analysis is to determine if there is a conflict of law, right? Does state A and state B have two different outcomes? If the answer is yes, how do we choose it? And so the court will look at what the contract says. It says, hey, is there a governing law provision? Generally, this will be applied. But again, if there's a conflict, they're going to apply this test. And the first question is whether or not the chosen state, that is the state in the contract, has a substantial relationship with the parties or the transaction, or whether there is a reasonable basis for the party's choice of law, right? So let's say that I'm in California, you're in Delaware, and we selected Maine law. Does Maine have a substantial relationship to the parties or the transactions? Probably not. Or whether and so the second question to that is whether there's a reasonable basis for the party's choice of law. Was there a reasonable basis for Maine? I don't know. Let's say that there's something out there that is appropriate. If the answer is no to any of those questions, so if you can't state that one, there's a substantial relationship, or there's no reasonable basis, then the court doesn't need to apply the choice of law. But if the answer is yet, we move on to a next part of an inquiry. The next test is whether the court, the chosen state's law is contrary to a fundamental policy of California or the chosen state, or the forum state. So a fundamental policy, that means it has to violate a statute or a constitutional right, something very deeply embedded within the public policy of the state that's making this determination. And so if there's no fundamental conflict, then the court can apply the law of the chosen state. But if there is a fundamental conflict, the court must then determine whether or not the forum state, so California in this case, has a materially greater interest than the chosen state in the determination of an issue. So again, it's a complex test that's very fact intensive, that is asking, one, is there a rational basis for the selection of the test, of the forum state? If the answer is yes, then we move on to, okay, does it violate a fundamental policy of the forum state? If the answer is yes, then you have to answer the question of, is there a materially greater interest in this outcome? So how does this play out? Let's say you've entered into a contract for a bad loan, for instance. Well, does the state that is enabling the bad loan have a greater interest in the determination of that issue over the state where the borrowers are located and need the protection of state laws to protect them from predatory lending? Generally speaking, the answer is probably not. So these are how these tests play out in the real world. And it's just a fascinating area of law.
Speaking of the loop, I wanted you to close this loop on arbitration provisions. Explain to the audience first, what is that? But how do the arbitration provisions interact with governing law clauses, especially, let's say, when the form and the governing state, they don't match?
By and large, arbitration provisions don't have a huge impact on choice of law. I'll frequently see, arbitration provisions say, "Hey, this is governed by the Federal Arbitration Act." Long story short, most states have a strong public policy of encouraging arbitration. This is a shift from, I believe it was the 1970s or so, where arbitration was kind of, you know, a redheaded stepchild that no one really wanted to deal with nor trust. But due to the fact that there's 330 million Americans, tons of business, and only one court system, the court needs to have some ability to have matters be heard outside of itself. So generally speaking, arbitration clauses aren't going to have a huge impact on choice of law. Choice of law and governing law provisions can impact it, but by and large, um, if you're going to compel somebody to arbitrate a dispute, that motion will likely be granted. And then you just have the same battle that we were just talking about, or about choice of law and whether or not the governing law is applicable. You'll just have that debate inside the arbitration.
Stephen, I should have asked you this at the beginning. What happens if a contract doesn't have a governing law clause? Like, how do the courts decide that and which law controls?
It's an even better question. Long story short, it defaults to common law standards. So depending if we're in federal court or if we're in state court, we're going to apply common law principles, which ironically mirror what we've talked about earlier, which is Restatement 187. There's a variety of different tests that can apply. Let's say it's a breach of contract claim. They're going to look at, okay, well, where was the contract formed? Where was performance? Some of these standards to determine which law applies. Otherwise, it could just be by default. Someone just files in Forum X and the parties just start applying that law to litigate the dispute. So it could just never come up. But yeah, it's basically the parties or the law that will apply will be the law that has the state with the most relationship between the parties.
Stephen, as we wrap on this episode, an executive that's listening to this, well, how would you advise them to evaluate governing law and venue terms within their contracts to be sure that they are offered real protection?
I would ask those CEOs to look at the regulatory risk and the business risk of their business. Are you a type of business that's likely to engage in litigation? Or are you a business that's unlikely to engage in litigation? If you have a lot of litigation, due to regulatory schemes or otherwise, just the risk profile of your business, certainly look at these provisions closely and make sure you stack your deck so that if something does come up, you can nip it in the bud for the other side. Otherwise, I would just advise business owners to think carefully before signing things, because it's more expensive to find an attorney in a different location where you have no connection than the folks around you in your community.
Stephen, thanks for the time. As always, we appreciate it.
Thank you for having me.
And that's it for today's episode of Litigation and Capital with Steven Mirsky. If you want to learn more about Steven and the team and the work that they do over at Mirsky Corporate Advisors, visit MirskyCorporateAdvisors.com. Thank you to everyone for listening to this episode, but do me a favor, like, subscribe, leave a review and comment, or share it with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.